Hello, my name is Bob Connolly. I'm an attorney here in Washington, D.C. I want to thank the European Competition Observatory for allowing me to make this video. I made one last year. I was a career prosecutor with the Antitrust Division, and last year I did a video that's hosted on their website that took a cartel investigation on the U.S. side from the very beginning to the end with who ends up going to prison. This year, I just want to do sort of a supplement to that, a highlight of some of the major developments that happened in 2014. I'll also provide a paper, so I won't be reading citations, but if you want more information, there's a paper that goes along with the video that will have citations to some of the things that I'll be speaking about. I also mentioned I have a blog. It's called Cartel Capers, and if you're interested in following U.S. cartel developments, you might want to check that out. So as most everybody knows, the big story in U.S. cartel prosecutions continued to be the automotive industry prosecutions, the auto parts cartel investigation. I'll just briefly mention some of the statistics you may have heard before, but there are up to 46 individuals charged in that case, 26 of whom who have pled guilty. There are 30 companies that have pled guilty, have paid fines over $2.4 billion. The investigation is at the stage now where the individuals are being indicted. These are higher level executives where in all likelihood, the Antitrust Division wanted to negotiate plea agreements with substantial amounts of jail time. Some of the plea agreements have had jail up to 2 years. So there are executives who will say, thank you very much, but I am going to decline your offer to come to the U.S. and go to prison, and I'll stay in Japan. So some of these people are being indicted now, and they will likely remain fugitives. I worked on a big cartel investigation back in the late 1990s, and there are still executives who are fugitives from that investigation. They will just simply stay in their home countries and not travel. Other big news in this side of the pond, and I guess in the EU as well, is the financial crimes investigations, the LIBOR investigation and the Forex investigation. I'm going to talk about them a little bit more because they are not pure antitrust or competition law violations. They are really a different species of fraud. But the Antitrust Division has been doing a lot of work on those investigations. LIBOR has resulted in big fines and some personal indictments of individuals. And Forex hasn't had any criminal activity yet, but it will soon. I'm quite certain of that. And those numbers in terms of fines will likely even dwarf the LIBOR investigation. There's also a fairly new investigation on the horizon, capacitors. And the U.S. is investigating that, but so is the EU, the JFTC, the KFTC, and for the first time the Chinese have been involved in the beginning of this investigation. That's going to be a big development to watch how China, when China now has a seat at the table as a cartel enforcer, how that develops. I do want to talk a little bit about, so Forex and LIBOR are joint investigations. The Department of Justice has an Antitrust Division and it has a criminal division. The Antitrust Division enforces competition law violations, Sherman Act violations. The criminal division has responsibility for all other criminal statutes in the United States, including fraud. And sometimes the conduct crosses over both lines, and that's what's happened in LIBOR and Forex. It's difficult to say whether this is a restraint of trade in the Sherman Act sense or it's a fraud. The criminal division and the Antitrust Division have joined forces. But they operate somewhat differently. The Antitrust Division has a leniency program. The criminal division doesn't. But the criminal division does deferred prosecution agreements, which the Antitrust Division doesn't. There are differences, too, between how the Antitrust Division and the criminal division treat compliance programs. But when they're doing a joint investigation, what determines what policy applies is not so much who's doing the investigation, but what is the nature of the offense. So a company can get leniency for collusion among competitors, but still face fraud charges. And and vice versa. But the two divisions work closely hand in hand, and it's transparent to the companies who they're dealing with and what the situation is. Another, it's not a development, it will be continually in the news, sometimes with great fanfare, sometimes recede, but the antitrust division had 2 instances of extradition in the last year. The most recent was just a week ago, where a Canadian businessman was extradited to the United States by the antitrust division, but he was facing fraud charges. This is another example where the antitrust division can do a criminal investigation, begin it by thinking they are investigating possible collusion among competitors, which would be an antitrust violation. But as you get into it, they may find out there was really different kinds of fraud involved. And once that investigation is underway, the antitrust division will normally maintain control of the investigation and prosecution. So this gentleman, John Bennett, he's been extradited from Canada to face charges by the antitrust division of fraud and kickbacks on some EPA Superfund cleanup projects in New Jersey. Another what was an antitrust development, an Italian citizen was extradited to the United States by the German authorities, Roman Pisciati, and that was somewhat controversial because Germany would not extradite one of its own citizens on an antitrust charge, but this gentleman was traveling in Germany. He was stopped by Interpol, and that's a reason why fugitives really can't travel, and why some people do choose to come to the U.S. and plead guilty. But in any event, it was a 9-month extradition battle. He was eventually extradited to the United States, and he pled guilty and agreed to serve 2 years in prison. An interesting twist on his plea agreement gave him, it was a 2-year plea agreement, but he got credit for the 9 months that he was in prison in Germany awaiting the extradition hearing results. And then the antitrust division, the government agreed they would not object to his serving the balance of his sentence in Italy. The catch to that is once you plead guilty, the antitrust division is not in control any longer. The Bureau of Prisons is. And there is a way to file the proper paperwork and get approval to serve a sentence in a foreign jurisdiction, but it can take up to a year. So it may be with 2 or 3 months left on his sentence that something like being able to serve the balance in Italy comes up. So that's the good news and the bad news. The good news is a foreign executive may be able to serve prison time in his or her own country. The bad news is you need a fairly long prison sentence to even make that viable for the time it would take to get that going. And in extradition, the big question is always going to be, will there be an extradition of a Japanese business person who's been indicted for an antitrust crime? Because far and away, the bulk of the fugitives from price-fixing cases in the United States are Japanese citizens. That's true in the auto parts investigation, and it's been true in others. And to date, there has been no extradition. I would be surprised if there is one, but I've been surprised before. And it would be big news if that happens. Compliance programs are in the news a little bit here in the United States. The first news is just that the Antitrust Division is even talking about them. It has generally been a subject that the division has maintained a policy of you won't get credit for a compliance program because if you're involved in an antitrust offense, that means senior level executives in your company have engaged in criminal antitrust activity, and so your compliance program was ineffective. That's still the position of the division, but they have addressed it in a couple of speeches. Bill Baer, the head of the Antitrust Division, and then his deputy for criminal enforcement, Brent Snyder, both gave speeches back in September, almost back to back, which dealt with the division's positions on compliance programs. And I'll have citations to both those speeches in the paper that will accompany this video. So the reason the Antitrust Division says they won't give credit for compliance programs is what I just articulated in their experience and in mine when I was a prosecutor. These offenses are committed at very high levels of the company, and they don't just involve one individual. They typically can run from a president down to a vice president, sales managers. This is true of the auto parts cartel investigation. It's true of most division investigations. So their position is that your antitrust compliance program was ineffective. And under those set of facts, that's also the position of the United States sentencing guidelines. You can't have senior executives of the company giving compliance speeches and then going out and fixing prices and expect to get credit for it. Still, the U.S. government has taken some heat because other countries do give credit for compliance programs. And in the United States, the criminal division that prosecutes, as I mentioned, all other types of criminal violations, they do give credit for compliance programs under certain circumstances. But here's an example. The criminal division prosecutes FCPA violations. And they have, on occasion in the past, declined a prosecution or given credit for sentencing for having a compliance program. But FCPA violations can often involve people far, far down in the chain of command, sometimes third-party vendors, lower-level people. It can be a different type of person that can get a company in trouble for an FCPA type violation, usually than an antitrust violation. One thing, though, about these two speeches that the division gave is more of a hammer, that they are going to take more serious action against companies who don't have compliance programs. In other words, you may not get a benefit for having one because it was violated, but if you don't have one, you run the risk of possibly being put on probation, or as they did in the AU Optronics case, they asked that company, the court, to impose a compliance monitor on that company. And that can be a burdensome thing for a company to have to deal with. And another development in these speeches that's worth keeping an eye on, the government, the antitrust division has said, if a company continues to employ senior executives who are culpable in the violation, who have not accepted responsibility, in other words, they haven't come to the United States and pled guilty, that may be an indication that they don't have a serious compliance program. That may be a problem because many companies, some companies at least, use what I call employee amnesty. If an antitrust investigation, competition law investigation breaks out, the company, when doing its internal investigation, needs to get the information as fast as they possibly can. And they may say to employees, if you come forward, tell us what happened, we won't fire you. But under the division's view, maybe later on, if you don't fire some of these culpable executives, it may be held against you. So it's just an area worth keeping an eye on to see how it plays out in real cases. Compliance programs, if you're a corporate counsel, there are dozens of areas where you would like to have the gold standard compliance program, the antitrust area, competition law, for FCPA violations, a lot of different areas where a company can potentially have liability. And compliance dollars are limited, executives' time is limited, so it isn't always maybe the level of compliance that you would like. But one thing that's worth mentioning is when red flags should go off, and I'll use a recent example. The Antitrust Division has just started an investigation of generic pharmaceutical companies for possibly fixing prices. Now, this investigation was started by subpoenas instead of search warrants or dawn raids, so that is generally an indication that the Antitrust Division may not have very strong evidence at this point. If they had stronger evidence, they'd probably proceed by search warrants. But one of the things that the Antitrust Division does, and compliance counsel should track as well, is The Antitrust Division will try and expand this investigation as much as possible. It started out with just 2 companies, but they will look at those companies and see who else do those companies compete against, what other products are involved, and sort of create a family tree of the executives in the company, the products they sell, their areas of responsibility. And when they question witnesses, they'll see if there's illegal conduct going on in other areas. They offer companies things like amnesty, Amnesty Plus. Tell us what happened in this product, and if you can expand it to other products, you get even more credit. So when Compliance Counsel sees that the Antitrust Division has started an investigation in product A, and your company is in that space, maybe not right in product A, but in product B, C, and D, that may be an awfully good time for some kind of an audit. Maybe not a price audit, those things can be very expensive and sometimes inconclusive, but check people's expense reports, do some interviews, just check to see if your company has liability in that area, because if you can discover it early, you can take advantage of things like amnesty and get credit for early cooperation, or at least limit the exposure by stopping the conduct. Making close to one of the last topics I want to talk about, it's important in Europe, it's important in the United States, is component price fixing. Where in the United States we put it, where does the jurisdiction of the Sherman Act extend to? There's competing interests. The United States wants to protect consumers in the United States from being overcharged, from price fixing activity, even if that activity takes place overseas. On the other hand, the United States doesn't want to be the court of resolving disputes about price fixing activities that may have happened anywhere over in the world. So where do you draw the line? And that's been a tough issue. And it's being litigated in U.S. courts now, and eventually it's going to get to the Supreme Court. But where it is right now is the U.S. law says foreign conduct can violate the Sherman Act if it has a direct, substantial, and reasonably foreseeable effect on U.S. commerce. So what is substantial? What is direct? These are questions that are going to be litigated. There'll be principles of law, and then they'll still be fact-specific. But it's going to be litigated in the United States courts. And then a second component of that is the foreign conduct has to give rise to the antitrust claim that's being brought. A prominent case in the U.S. is called Motorola Mobility. It deals with the LCD cartel, where the United States successfully prosecuted quite a few companies, many individuals, and fines were paid in the EU and elsewhere around the world. It was a very successful investigation from the enforcer's point of view. In the United States, as you know, there's a rich tradition of plaintiffs, litigation then seeking damages. So private class action damages have been filed in the United States, collective redress actions, I think they'd be called, in Europe. And the questions come up in some of those cases about whether the conduct had a direct, substantial, and reasonably foreseeable effect in the United States, and whether it's the cause of the plaintiff's injury. So in the Motorola Mobility case, which was Motorola suing for damages, a number of foreign governments, including Belgium, filed briefs with the court saying, we really urge you not to take an expansive view of what U.S. jurisdiction is over foreign commerce, foreign conduct. And a key fact in the Motorola Mobility case for the civil cases was that the purchases of the LCD panels that were fixed were made not by Motorola in the United States, but by Motorola subsidiaries operating in Taiwan, China, and other countries, so that the argument is the antitrust injury took place overseas, not in the United States. It's a complicated area. Again, I'll put some citations in the paper to some of the prominent cases and an article I've written on the subject. But it's something that's going to be developing and keep an eye on. It may come up in the capacitors investigation. I don't know, it's brand new investigation, I don't know all the facts, but say hypothetically, capacitors are put, I think there's over 400 of them in an iPhone, but they cost substantially less than a penny. And if they were bought, sold, and assembled overseas, would that meet jurisdiction requirements in the United States? It would seemingly be quite different than the LCD screen, which comprised up to 40% of the cost of a phone. But what if the components in the phone are pennies? But there's a lot of them. Interesting questions, and just something to keep an eye on. And all jurisdictions are dealing with this because components are just ubiquitous. Components made around the world, assembled around the world, are ubiquitous in products bought by consumers in the United States, in Europe, and elsewhere. So it's just a summary of some of the key events that happened in 2014. 2014 isn't quite over. I think by the end of the year, there's going to be a big splash with announcements of corporate plea agreements in Forex. There may be developments in other investigations. But if you're interested, the Antitrust Division, the way it operates, it tries to be very transparent, very predictable. What are their policies? And if you go back to the talk that I have on the website last year, it'll go through all those policies dealing from amnesty to amnesty plus, negotiating plea agreements, and how to deal with the Antitrust Division, or what to expect from the Antitrust Division. So that is a stable organization that values consistency, values transparency, but issues do continue to arise. As I mentioned, this component price fixing is going to be a big issue. Corporate compliance may be a big issue. The Antitrust Division, I think, would like to join other jurisdictions where they can give credit for a compliance program, but they're only going to do so in a rare or unusual case where a company can make the case that we had a strong compliance program and somebody very far down the organization, maybe a district manager, maybe a salesman in one territory, maybe an estimator, had conversations with their competitor that they shouldn't have had. The Antitrust Division may be open in a case like that to giving credit for an otherwise strong compliance program, but as long as it's senior executive involved, and a number of them, I think their position will be the same on compliance program. As I understand it is in the EU, that it's not something that you can get credit for when the level of involvement is senior executives. So I hope this was helpful, and feel free to reach out to me if you have any questions, and thank you for your time.